someone else has them as well. Two things I want to say. One is when you consider the overlap of some of the conversations between the sections, this is why we put together this way. As you deal with one of these areas, it overlaps with another area, right? And then I was just talking about the mic. Another area that's come up is really around how we approach things like wealth management and financial planning. And one of the things we're considering is having another one of those. We had it a couple years ago, just to kind of help wrap those things together. So again, thank you for that. Our next section is really now to go deeper into the legal aspects of some of these conversations. So we have, again, Brother David Lewis, who'll come up, and I've given him a time limit. He's promised me no baseball story. No, he didn't promise that. I'm kidding. Yeah, but that's a little inside joke for us. But all kidding aside, Brother David, come on up.
Thank you, Brother Ernie. Yeah, it's a pleasure being here, and I want to say thank you for all those who have gathered here for this session. And by all means, listen to what I have to say. If you have questions that are pertinent, ask the questions. And if I don't have the answer today, I can check on it and get answers for you. As has already been mentioned, I am an attorney at law. I'm licensed to practice law before all of the courts in the great state of California, and I'm very privileged to do that. But I'm not saying that I'm an expert in all these areas. I feel confident and I'm knowledgeable in the areas that I practice in, and I have some knowledge of some other areas also. But for the things that I have knowledge of, I'll give you my best effort and information. And things that I don't have, I can certainly help you to find or locate someone who can get the information for you or can help you. I want to thank Marcia. She did a good job of making her presentation, and some of her areas kind of overlap. I only say over into some of my areas also. So I appreciate having a church member as well as a family member with her expertise. Okay, so the slides I have here have the information on them. Feel free to take notes, and at the end, if there's something that you want to see again, I can show you that, or I can even send you the entire PowerPoint presentation. I have no problem with that. Okay, so that's just my information there. What I'm trying to do here is I'm trying to present to you some legal considerations for your estate planning. And I'm trying to do it without using a whole lot of legal jargon or a lot of legalese, because sometimes people get lost in the translation because of all the terminology that's being used. The terms that I am going to use, I'll try to define and explain those to you. That's my office information there I have on the front slide, and I'll have it again at the end of the presentation also, okay? All right, so first of all, what is your estate? When people say estate planning, what does that mean? Estate planning. What's your estate? So your estate can be a number of things that you own or in control of. It's going to be your real property, if you have property. If you have an apartment building, it's even a cemetery plot. Anything that has to do with real estate, that's part of your estate. But your estate is also your investment property. So if you have stocks, you have shares of some company, you have some kind of investment portfolio, that is also part of your estate. Estate is also personal property, things that you have that are tangible, like your car, furniture, artwork that you might have, or things that you collect that is worth something, even jewelry. That's part of your personal property. That's in your estate. Even your finances are part of your estate. So your bank accounts you might have, as well as your insurance policies, those are part of your estate. And then there's some other things, too, that may be miscellaneous things that are not listed here, but those can also be part of your estate. So anything that you have in your possession or your control of that you want to pass on to others when you become deceased, that is part of your estate. And so people need to consider what they want to pass on to their relatives or their loved ones when they become deceased. Nobody wants to talk about dying. And a lot of people don't even want to think about dying. But sure enough, all of us are going to die one day. And so we need to have those difficult conversations and to think about those things and then talk with our spouse or talk with our children or our loved ones about those things. And so that's the purpose for my presentation, to get us thinking about those things if we haven't done it yet, and making plans or start working on them. Or if you have already done it, you may have some questions about things that have been done already. Okay? So the first question people often ask is, when? When should I begin in my estate planning? And it varies depending on the person or on the couple. I would say probably, once you have acquired a significant amount of property or finances, money, or other valuable assets, you should start planning then, okay? So if you're a 20-year-old and you're still, in college and you're in your third year, it's probably not a need for you to do estate planning at that point, unless you're in a Rockefeller family or some other family you were born into wealth. But once you start acquiring things that are significant, then you need to start thinking about estate planning. The ideal ages or age range would be between age 30 to 60. Somewhere in that age range, you should start doing your estate planning. Okay? And the idea is that you want to be able to decide. You want to be able to decide what's going to happen to your estate and your things when you become either deceased, or even if you become incapacitated, when you can't control things and handle business the way you wanted to before. Because even incapacitation is something that's part of estate planning. Okay, so estate planning from a legal point of view usually involves these options right here: a will, a living trust, a durable power of attorney or other powers of attorney, like special or limited, advanced health care directive, conservatorship, and even guardianships. So these are some of the things I'll be discussing in this presentation. Okay, and these are things that you have heard about, you have some knowledge of, but I want to give a little bit more detail and information that might help you to assess which one you want to use or how you want to go. Okay, first of all, a will. This is the most common term in estate planning, a will. But a lot of people don't even know what the requirements are for wills. So a will it's a written document, first of all. It identifies the testator, and this is one of the legal terms I'm using here. And the testator is the person who's leaving the will, the person who is leaving the will. The will also involves the heirs, and the heirs are the people who are going to inherit the property or the items that are being given or being transferred. And the will also will contain terms, letting people know under what conditions will these things be transferred. And by the way, if you inherit something through a will, or anywhere you inherited in the state of California, it's considered your separate property. Even if you're married, it's separate property. It is not community property. And that's important because sometimes it's important to know who can make the decision or the final call on property. But if you inherit it, that's separate property in California. The will is often called the last will and testament. And testament just means that it's like a contract or an agreement. This is what's going to be happening, okay? The requirements are this. The person who is the originator of the testator, they must be an adult of sound mind. The language of sound mind and body is usually put in the will, but really body doesn't really matter. I mean, if a person has a bad hip or a broken shoulder, that makes no difference. It's the sound mind, though. You have to have a sound mind. That means you can't have a person who is mentally incapacitated, or you can't have a person who is in the final stages of Alzheimer's. They're not able to do a will at that point. So the person must be of sound mind, and the person must have a knowledge of their assets. They must know what their assets are. So there's even some language in the will saying, I'm fully aware of the extent of my estate. That means you know about your bank accounts and your property and your house and what have you. And that language is always in the first part of the will. The will must be in writing, as I mentioned before. It must be witnessed by two disinterested parties. And disinterested means people who are not heirs. They're not inheriting anything. So you have to have the witnesses sign at the end of the document. And it has to be two people who are not taking or receiving anything under the will. And that's a California requirement. It does not have to be notarized. Sometimes it's a good idea to get it notarized because you may not be able to locate the witnesses to verify things later on. But in California, the will does not have to be notarized to be valid or legal. but it does have to be witnessed by two disinterested parties. Okay? So these are the parts of a will, and it varies. Sometimes people have long will, have short wills, depending on what the extent of their estate is. But there's a opening statement usually about the person being of sound mind and knowing about their own estate and their property. It must identify who the testator is, the one who is making the will. It must nominate the executor, okay? An executor is going to be the person who will be taking over once you become deceased, okay? And it must give the instructions and the role of the executor, say what the executor will be doing. And then it has to describe what the estate is and what's in the estate. So the property of the estate, bank accounts, investment accounts, and any other valuable assets. So that would include, say, your car, your jewelry, and your collections. And then there would be terms and instructions there which the executor is bound to follow. Okay, so so sometimes they'll give the executor the leeway and latitude to make their own decisions, but other times there'll be things that you specifically want the executor to do. And then beneficiaries will be listed, those who will be inheriting things in the will. If a minor is listed as inheriting things in the will, then there must be a guardian placed over that minor, because the minor is not able to receive things legally on their own. So the guardian will usually be another relative, and there may be a separate legal requirement for that. Then you may have to go into court and be appointed as a guardian. And I'll mention guardianships a little bit later on also. Okay, those are parts of the will. Okay, and the law and wills. Okay, so people know about wills, but what they don't know is what makes a will valid. How we know that the will is going to be followed, and when does the will take effect? Well, it takes effect when the testator dies. So regardless of what's in the will, if the person is alive still, it does not take effect. It only takes effect when the testator dies. And the will in California must be properly probated. And that means you have to have court approval. A judge must sign off on it and issue orders before the will can be operable. Okay? It must be probated. And the person who's identified to act as the executor or executrix, can be a man or a woman, then that person is the one who usually will file the paperwork with the court in order to probate the will. And by the way, there can be more than one executor. You can have co-executors. It can be two people listed as executors. It must be filed, the will must be filed with the probate court in the county where the person who died lives, or where they have most of their assets. So if they had two homes, wherever they have most of their assets, then that's really be the proper county that you're going to file it in. And in California, and in our area here, we have two, in LA County, there are two courts that handle probate. One is downtown Los Angeles on Hill Street. The other one is in Lancaster. And so those are two ones in LA County. San Bernardino County only has one, and they're at the Justice Center over there on West 3rd Street. And I practice law in this area, so I go back and forth between those courts quite often. Okay, to make a will valid, the court first asks, is this the original will? And people sometimes have lost the original will, but they have copies of it. But they want to see if it's the original will first of all. And if it's the original will, it has to be submitted to the court, and there's some things that the judge will do to examine it and make sure that it's valid. Okay? If it is not the original will, it is a copy, then you have to file a special petition to probate a lost will. We assume the other one, the original, has been lost, and sometimes that happens. People write wills out and they have it somewhere, you store it somewhere, and they forget, or they moved a few times, and it got lost somewhere. But if you have a copy of it, you can still get it probated. So you file the petition to probate the will, and there's a filing fee involved. Right now, the filing fee is about $435. It could be going up from that. And if you have an attorney representing you, you have to pay the attorney's fees also. Okay, and then sometimes a bond will be required if there's a house or real property that's involved, and the bond will be based on the value of the property. So that's more money also. And then people say, well, how long does it take to get the will probated? It depends, but it could be anywhere from 3 to 6 months or even longer if there's some complications. And there are people other people can contest the will. If they don't like what the will says, or they find out that they're not part of it, and they think it was unfair, or they might think there was undue influence by someone who is an heir. And so people can oppose a will, and that also can prolong the process. So you see, these are some of the things that make the will not as desirable as other forms of testamentary documents. And speaking of other forms of testamentary documents, a living trust is another way to pass on your property. And so people have the option of doing a living trust or doing a will. I always advise people to do a living trust, okay? And here's why. The living trust is a document that sets up the estate that's going to be managed or controlled by a person while they're still alive. So you are in control of your own trust while you're still alive. That's why it's called living trust. And the estate, your estate, is called the trust. And there's a document called a trust instrument that has all your estate listed in it. And it can contain the same property items that we have mentioned before in the will. Same things can be in the living trust. And it's a testamentary document also, which means that when you die, there are things that will take place, and your heirs and your descendants will need to know about those things. Good thing about a living trust, though, is it does not have to be probated. You don't have to go to court and file anything. So no probate court, no probate fees, and maybe even no attorney's fees, okay? Although sometimes you might want to consult with an attorney if you have a trust that you have questions about. But those are the advantages of having a living trust over doing a will. Okay. Now they recommend if you have huge estates with billions of dollars that you might want to do the will anyway, because you might need to have court control over certain things. But for regular people, normal things, normal assets, and you only have assets of $3 million or under, living trust is preferable. Okay. Oh. Yeah, we're going to get a mic to Mike. Microphone to Brother Michael Harris. Yeah, so what I'm doing right now, I'm contrasting living trust with the will. And I'm showing you why a living trust is preferable, why I advise clients to do a living trust. Yes.
As you aforementioned, a living trust is more desirable than a will.
Yes.
We just went through this with my mother-in-law, with 11 kids and a home that was worth $1 million.
Okay.
So different pools was, when she was alive, before she became ill, was deciding to get a will. I said, no, do a living trust. Mm-hmm. And in this trust, have her, make her, as you got listed up there, desire what she wants to have done with the property,
right,
how it needs to be, who is going to be the executor, that became my wife, and that her decisions cannot be contested in the sense of what the mother has said she wants done. So my question was going to be posed. In this said living trust, she was on SSI. She had the trust turned over, the property turned over to the trust. It no longer belonged to her. It belonged to the trust.
Yeah.
Once that happens, she was still able to get her SSI and do all the things to get benefits and so forth. And she didn't have it listed as her property. It was the trust that had the property.
The trust owned the house.
Yes. Mm-hmm. So in that situation, when Mike was saying about, having different assets, if the assets are put into the trust and you have a operating LLC under it that is doing all of the property management, the da-da-da-da-das, the overviewing of all these things that needs to be done. And the executor is just overviewing the conservator that is watching over the properties, the business, whatever it is that they have that's in the LLC. There's nothing in it that has Mike's name or my mother-in-law's name on it, so she was still able to get the benefits from her SSI because the home wasn't in her name. It was the trust that had it. Okay. So my question is this something that we can say is a good path to take?
Yeah, so is that advisable to do it that way?
Yes, sir.
Okay, first of all, there are no absolutes in the law. Remember that. So there are exceptions to every rule. But the way you describe it, though, it is a good way to handle your estate, and also to keep it separate from your own personal liabilities. Okay, and a living trust is a separate entity from the person. It's separate, and so it does protect the property. Okay, and most time, the living trust though is in the name of the person. It will say the Michael Harris Living Trust or Revocable Living Trust. So it's in the name of the person usually. If you said that they have an LLC, so they may be in the name of a company instead. That's acceptable. You can do that also. But usually a living trust is in the name of the person, okay? And it's a separate entity. There are some tax consequences sometimes that have to be considered, and I'm not a tax expert, so I would advise people to check, with their tax professionals, okay? But way you describe it, though, that is a good way to protect the assets and to keep separate the person's property and income from that which belongs to the trust. That's another good reason to have a living trust. Okay, yeah. Sister Irby, you had a question on this?
I do have a question. When you have a living trust, the trustee, many times, which is a family member, is in charge of the distribution of the trust. But an LLC is a limited liability company which is transferred away from the member to execute the trust. Am I saying that correctly?
Well, yes. And Mike was using some terminology. Mike mixed up some of his terms. There is no executor in a living trust, Mike. It's called the trustee. Yeah, and the trustee is the one that makes the decision and also handles things. So when you're alive, you are the trustee yourself, okay? You can identify successor trustees, but trustees are able to hire professionals to handle things for them. So a trustee can hire an accountant, can hire a lawyer, can hire an investment, and have those people. You can direct those people to handle things for the company or for the business that is part of the trust. Okay.
One other question. Since California is a community state and you only have one spouse, isn't it true, unless you have it stipulated otherwise, that your assets are automatically hers?
Okay, no, it's not automatically. California is a community property state, and so the presumption is anything that you earn during the course of the marriage or that you acquire during the course of the marriage is community property that's owned evenly by both of you. But there are some exceptions to that. If you get something as a gift from a relative, or if you inherit something through a will, then that is separate property. Okay, yeah. But California is probably on the cutting edge for most of these type things, and the other states are not as progressive, and also it's not as complete as California. And that's why California and New York are usually the models that people look at when they're trying to figure out how to do certain legal entities. Okay, so as I was saying, living trust is more advantageous than doing a last will and testament. I heard someone say you do a living trust and then no one can contest it. Well, that's not exactly true. A person can contest even a living trust, but it's got to rise to a certain level. Otherwise, they're wasting their time. Because a living trust is almost foolproof. If someone thinks there was some fraud that took place, then they could go to court, and try to oppose a living trust. Or if they think that the trustee has not been following through with the instructions in the living trust. Then a person could go to court and they can, basically, they're basically suing the trustee or getting them to getting the court to order the trustee to follow the instructions in the trust. Okay, so just so you know that even though you have a living trust, there are some times when you might end up in a court battle. Now, I personally, I do estate planning, so I draft and set up living trusts and the wills. I don't necessarily litigate issues if someone's contesting wills or a living trust, unless it's one that I was personally involved in. Okay, there was another question there.
Brother Jeff has one.
Okay, yes.
So if in the case of if you have a trust or a will and your spouse automatically doesn't become the executor
No.
when you die, so you have to make sure you designate someone?
Yeah. So, if you have a spouse and you own the property, usually it's going to be a jointly owned property, and that means that your spouse has the right of survivorship, and you die, and the spouse automatically becomes the sole owner of the property. Okay. But if you're setting up a trust or even a will, there's no automatic anything. It has to be specified in there. So a husband and wife can have separate wills or separate living trusts, or they can have joint wills and joint living trusts. It's up to them. And most people do joint living trusts, and so they have both of the spouses' names listed there. Yes, Brother Mike and then Sister Irvie. Yeah.
I was just going to mention, because we went through that, the kids, it's all spelled out of how you set up the trust.
Yes.
So if one of the trust recipients die, then she had it stipulated that the grandkids would get the share, but not the mate. And she wanted it that way because she said that she wanted to make sure she left something for her grandchildren, not somebody that wasn't her blood.
Okay. Is that a statement or question?
I think what I'm going to say is wrapped up in what you were thinking, that if you have other children, then you have more of a detailed trust in allocating portions of your trust to those kids other than your wife who lives in a community estate in which you just have a house or something with a state.
Yeah, that's certainly it's something to consider. That's why people do estate planning. They want to see what they're going to pass on, and who will be passed to. And people are concerned about their children always, and sometimes they're even concerned about their grandchildren. And so the beauty of a living trust is it's up to you. You're the architect of that living trust, and you set it up the way you want to, as long as you're using legal terminology and you're following the probate law in California. I think I'm probably going to cover a couple of these things here on my next slide, a slide or two here. People have a lot of questions about living trust because that is the preferred way to go. So I appreciate the questions you guys are having. So the living trust, the person who sets it up, or the persons, is called the trustor or settlor, okay? And the settlors are also the first trustees. You're the original trustees, and you're still alive, okay? After you have become deceased, you have to identify who will be your successor trustees, and that is usually an adult child, but it doesn't have to be. It can also be another relative. I had a case recently where the successor trustee was a niece that the woman was very close to, and she trusted that niece and to take charge of the affairs of the estate when she passed away. Okay, control of the trust is then given to whoever is listed as the successor trustee, and there can be more than one trustee and more than one successor trustees. Now, here's the thing: make sure that it's legally set up. The trust instrument must be signed in the handwriting of the trustor or settlor. It must be signed by that person, and it must be notarized, signed and notarized. Sometimes people make the mistake of signing the document after the lawyer gives it to them and then taking it somewhere to get it notarized. You're supposed to not sign it until you're in front of the notary, because the notary is supposed to verify that this person has presented themselves with proper ID and has signed in front of them. Sometimes notaries will go ahead and let it slide, and they'll have the person sign some of the document while they're there. But technically speaking, you're supposed to wait until you're in front of the notary before you sign the document. Yes, Mr. Irby.
When you have a will signed by other people and one person that co-signed the will passes on, are you to get another will signed? I'm going back to the wills now versus the.
No, it's still valid. Yeah, it's valid if the two disinterested parties were there when when the will was signed at the very end of it.
And if they die or move away, you can't locate
Doesn't
them?
matter.
Doesn't matter?
No, doesn't matter. I mean, if there's a will contest and someone is contesting,
Yeah.
one of those parties, it might make it a little bit difficult, if the person passed on. But that will is valid though. It's valid once it has been signed if the two people are disinterested parties. And that does happen. Sometimes both parties may have passed on
Right.
by the time the will is probated. And so a person has to, the person who is submitting the petition has to submit an affidavit or a declaration under penalty of perjury, stating that this person was alive when they witnessed it.
Okay, thanks.
Okay. Yes.
Brother David, just on what she was saying, got a will, I bought a car and some other jewelry, but I die.
Mm-hmm.
Can you touch on a pour-over will?
Yeah, I actually I'll have that in just a few minutes. What a pour-over will is, but a pour-over will should be part of a living trust document. Okay, let's see. I was talking about what makes a living trust valid. It's got to be signed and notarized, by the person who is setting up the trust. It does not have to be lengthy to be valid. I've seen living trusts that are like 50 pages long, and they have about 30 or 35 pages of legalese that's unnecessary because it does not apply to the individual people. But that's what happens when you go to a large law firm sometimes, and they'll charge your arm and a leg, and they want to make sure that they're showing you that they're doing their due diligence and they're doing their work, and they get this huge document. When I draft my living trust documents, I try to keep them short and to the point, and make sure that they're tailored for the client, and not a boilerplate document that has a lot of pages that don't apply. So I just want to warn you that if you see a lawyer preparing that 50 or 60-page living trust document, ask him if all those things are really necessary in your case. Okay, these are the parts of the trust instrument that must be in the living trust. It must contain the effective date, the date this trust is effective. It must identify the people or the person who is setting it up. It can be a husband and wife together, or it can be one of them separately. But it must identify the person who's setting it up, and that person is called the settlor or the trustor. It must contain a certification of trust. It's a one-page document that says this certifies that this living trust is hereby in effect, and I am the settlor, and this is the date. It must be a declaration of trust that has just the basic information. A lot of times banks or lenders will want to see that document when you're trying to transact things later on, and they'll ask the successor trustee, please show us the declaration of trust or show us the certification of trust, that one-page document. They don't need to have the whole document, but they usually ask for one of those two documents. The document must indicate who the original trustee is. It must identify the successor trustees. And successor trustees are often listed in multiple levels. So you have a first successor trustee, and if he or she is not available, then there's a second successor trustee. If he or she is not available, then it can be a third one also. And they can be co-trustees also, but you need to have at least two levels of successor trustees after the original people have died. The trust instrument can have limitations in it. It can also have excluded persons, people who you don't want to receive anything, don't want to get anything. In the will, we call that the disinherited clause. There's some people who are disinherited. I don't want Bob to get one thin dime. You put it in there, and there's no way that Bob can contest that. He can contest it, but usually he won't win. But you have the authority in a will to disinherit, and you have the authority in a living trust to limit or exclude people from getting any assets from your property. The living trust must describe the purpose of the trust, and it could be just to handle and manage the affairs of the parties, or it could be a specific purpose. There's a thing called a spendthrift trust, where people who are very, very wealthy they have children or grandchildren who they want to give money to, but because the person is young or inexperienced, they're limited as to how much of the money they can actually handle and get. And it's called a spendthrift trust, and there's some limitations on it. Okay. The trust should include instructions to the successor trustees. And this is one of the most important parts that I feel. You put in there how you want things to be handled, what you want to have done, so that when you do pass on, the successor trustee does not have to use their own judgment or not have to play the guessing game. They follow what you have listed there. And you can list everything in there, okay, including your funeral arrangements, your cemetery plots, how you want to have the service, where you want the memorial service to be held, and so forth. All those type of things can be in there, and that's very helpful. The living trust must indicate who the beneficiaries are and what the percentages of their interest will be. Is it a 50-50 share of the trust property, or is it equal shares? The trust will tell the trustee what to do with the real estate. Maybe keep it and maintain it in the family for years and years, or maybe sell it and divide the proceeds among the people who are the beneficiaries. It's up to whatever's in the instructions. Okay, a good trust should always have a pour-over will, Brother Mike. And a pour-over will is simply an extra part at the end that says, if I forgot anything, if I did not include something, or if later on I acquired something, then it automatically will be part of this living trust. It pours over into the living trust, and everything that we said about the other previous assets will be true of this one here also. And so you usually attach that at the very end of living trust, a pour-over will. It's a short document. It has the will language there, but also says that everything that comes up later on automatically pours over. And that way you can avoid the problem of not having an amendment that's up to date. Okay? So trust property can be a house, a building, bank accounts, investment accounts, automobiles, art pieces, and so forth. If the trust property is a house, and I say that 90% of people who do living trust, they want to put their home in the living trust. It has to be after the living trust has been set up and properly notarized. It's in effect right then. But there's one more step you have to do. You must record it with the county recorder's office, so that the deed now reflects that the house now belongs to the living trust and not to the individuals. That's a problem, and people often don't do that last step, and then you have a living trust, but the deed still is in the name of the person. And when the person dies, it can be very hard for you to do any transaction with that property. So it's very important to have it recorded with the county recorder's office, and they will often make you jump through a number of hoops, but you have to hang in there with it, or get a good lawyer who can help you get through that. And that's one of the things that I do. I navigate with the county recorder's office, because it can be troublesome sometimes.
There you go.
If it isn't deeded, does this automatically make the property go into probate?
That doesn't automatically, but if you can't resolve it, you must go to the probate court. And so, you could try, to show, that this was the intention of the parties, and they had the paperwork together, but they didn't file that with the county recorder's office. Then if you try to sell the property, you're going to find that either the lender or the different companies who are checking the paperwork, they're going to stop right there and see a red flag. And then you might have to go to probate court and get a mini probate petition to get to cover that little gap there that wasn't covered properly. So that's a good question. People need to record the property that's in the living trust with the county recorder's office. Otherwise, you might find yourself having to go to court anyway. You won't have to do all the things that you have to do in a regular petition, but some of those things will be required, yes. bank accounts and investment accounts can be put into a living trust, but if you do, you have to notify the bank and also the account and the investment office and let them know. And sometimes they have other forms you have to fill out when you do that. I advise not doing that. I advise you list your bank accounts and list the insurance policies and investment accounts listed in the in Schedule A as the assets, and make sure that that the trustee, the successor trustee, knows where those accounts are located and has the account numbers so they can transact business for you. And then go to the bank and say, this person has a right of survivorship on our account. You add your son or daughter's name to it, and then there's no problem. You pass away, your son or daughter's name is right there. You don't have to come and show the whole living trust instrument. So I recommend that you don't put bank accounts, investment accounts, and insurance information into the trust. You can if you want to. You can make the trust the beneficiary of your life insurance policy, but it's probably better just to add the children's name as beneficiaries with the insurance company or with the investment broker. Okay. Yes, Sister Herbie.
Scoot over.
Yeah, have Sister Herbie sit on the edge there, and her and Cynthia switch places.
If you have, let's say, for example, CDs of a certain dollar amounts, and you have POD, now this does not have to be into the trust.
Right.
Or
It
the
is not-
will, actually.
it is not to
because
put
you are
into the
stipulating
trust.
when you're alive that when something happened that this distribution should be at point of death.
Yeah. So at the point of death, there should be a person listed with the bank officials, but it does not have to be put into the trust. I'm just suggesting you have it listed in the trust so that the successor knows about it and can handle the affairs properly. So not everything has to be made a part of the trust, but you should at least list it in the trust instrument, and especially in the instructions. You would tell them, in case I die, contact Bank of America, and Cynthia Marbury has been listed as my POD person, and she's authorized, Oh, I'm using it for example. Is that your Bank of America? Oh, no. Yes, but the mic.
I suggest do what you're saying, make sure it's added, because anything that's not in that trust, who is responsible to have it? Because now there's nothing saying a car or whatever that was not there, that pour over should put it back into the trust. So
Yeah, there's several ways you can do it. So I say list it, in the trust, and make sure it's in the trust instructions, and then also contact, the bank officials or the investment account people, and let them know who is going to be the person who will take over upon your death. And that way you cover yourself. Sometimes if you put it in the trust, they'll want you to take it out of the trust before you can do anything with the account. So that's why you want to be careful about officially putting it in the trust. But list it, though. There's a thing called Schedule A, where you list the assets of the trust. And so Schedule A can have everything that is going to be in the trust. And then you can put additional schedules there of things that you want to know that are part of the estate but will not be in the trust. And so the lawyer who drafts that needs to draft it carefully so that it's understood that these things are listed here, but they're not part of the trust. But you do want the successor trustee to know how to handle it. Okay? And it's very important that you give good instructions to the successor trustees. While you're alive, there's no problem, and you're the initial trustee. But once you have passed on, you want to make sure that your children or your relatives, whoever it is, they know exactly what you want them to do with that property. Cars can be put into the trust. So if the car is paid for, you pass away, the person who is listed as a beneficiary of the car, they can get it, but they'll have to show some documents to the Department of Motor Vehicles to get the title transferred over. And it's not a problem usually. The problem is usually with bank accounts. Art pieces, if you have some nice art pieces or you collect some valuable thing, or you have jewelry, put those, list those in Schedule A and identify who gets them. Otherwise, the trustee has to make a decision on their own. Now, you may want them to make the decision on their own. If you do it, it's okay. All right. Any valuable collectibles you have should be listed, though, in either Schedule A or in some of the other schedules. Okay. Power of the successor trustee. Okay. He or she is entitled to take any action they desire to do as long as it's in accordance with the instructions in the trust. So sometimes they have a lot of latitude, and you want them to have latitude to be able to make decisions as things come up. Other times you want things to be done specifically. Okay, we mentioned about the house being transferred into the trust. The house can be maintained and owned by the trust for a long time. Or if you want, it can be sold and the proceeds can be distributed to the beneficiaries. Or it can be used as rental property or investment property. It's whatever is listed in the trustee instructions. That's what must be followed. And sometimes there is full latitude that the successor trustees have. Someone mentioned earlier about having accountants, what have you, in charge of certain things. The trustee does not have to be an expert in all these areas. The fact that you identify them as the successor trustee means that they're in charge of it. But they don't have to have knowledge of all these areas here. They can hire responsible professionals to help them do certain things. They can hire accountants, hire a tax person, a lawyer, an investment broker, anything. But make sure that the paperwork is handled correctly, and you have a paper trail showing the monies that were spent on behalf of the estate. All right, now here's a big question. We discussed wills. We discussed living trust, but what if there's neither? What if there's no will and no living trust, and there's a nice house, over in Baldwin Park, and they're trying to figure out who gets the house and what do we do with it? In that case, you got to go to court. You have to file what's called a petition to administer the estate because there is no will and there's no living trust there. And someone has got to be able to file it who's close to the person who passed away. It's usually going to be a spouse, a child, or a relative. Okay, it cannot be a guy off the street who knew him back in the day. No, and the judge will say, "How do you know him? What's your connection here?" You have to have some real connection there. So someone has to file a petition to administer the estate with the probate court. It must be filed in the county where the property is located, and here we go again. You're gonna have to pay some fees. Filing fees, attorney's fees, and a number of other things there. Let's see. I think on the next slide here, I have identified some of the fees there. But I'll take your question first, though, Sister Irby.
Well, you're probably going to get it in the next section, but I was wondering if you wanted to expand on the cost of probate that is based on the value, not the net outstanding liability on the asset.
Okay. Yeah, and usually it has to do with the house primarily, but there's, on the second page of the petition, you have to list or estimate the value of the estate. So you have the property there, and you have other things that may be of value, personal property, and then you have liabilities or bills there, and then you have to calculate what the net value is. So I think that's on the second page of the petition. And petition is a 5-page document. You're not held to that, though. It just gives the judge an idea of what you're looking at when you first filed it. Okay. No, I don't have that here, but I do want to mention costs. So there's a probate filing fee, which right now in LA County is $435. You don't have to hire an attorney to do it, to do the will or the administration of the estate. But if you don't, though, there can be some problems because most people don't have the background or understanding to be able to handle the whole thing for themselves. You can probably get it started by filing it, but there's a lot of nuances and a lot of terminology that you won't be familiar with, and you're not familiar with the procedures in the court. And probate judges are very strict; they're very sticklers. They jump all over us, and we make little mistakes, and we're lawyers. So for a person that does not know, it can sometimes be very, very problematic if you try to handle it by yourself. So I recommend getting an attorney to help you do the administration of the estate. And so you got to pay the attorney's fees, and he or she will work that out with you. You have to get a bond if there's a house involved, and the bond is based on the value of the house, and the judge sets the bond. And I put an example there. For example, if you had a house that was worth about $500,000, the bond would be probably about $1,800. What is a bond? A bond is like an insurance policy that protects the administrator against the other people who stand to inherit the property. In case the administrator made a mistake in some way or another and end up losing some money, you know, that bond is like an insurance policy to cover whatever damages there are. And you can get the bond waived under certain circumstances, but judges in L.A. County do not like to waive bond. They want the bond to be placed so that it protects all other parties, especially if there are people who stand to inherit who are not able to come to court. And so that's a cost that the petitioner has to incur also. Okay, so these things have to be filed with the court, and then the court has to approve the documents. And once everything has been approved and done properly, then the court will issue what's called an order to appoint the person as the administrator of the estate. Okay, and once you have that, then you can do some things with the property, even if you sell the property. And the court also gives you a document called the letters of administration. It's hard to get those documents, though, from the court. You have to go through a series of investigations, and you have to clear what's called the probate notes. And in my experience, it always takes 2, 3, or 4 hearings before you can do that. And the problem is the courts are crowded. So you can't go to court on Tuesday and go back to in the following Tuesday and get things done, because they have to set the new hearing day based on the court calendar. And the calendar is usually full for the next 2 or 3 months. So maybe 2 or 3 months before you come back for your second hearing, you know. So that can also slow things up. The process can take anywhere from 3 to 6 months, assuming that there's no opposition. But sometimes people get wind of it and they have to oppose it. Oh, by the way, you have to also publish a notice that you're filing a petition to administer the estate, so that the public can be aware of it. So just like in a probated will situation, a petitioner to administer the estate, they have to publish a notice in a legal newspaper, and it must be published for 3 consecutive weeks in a legal newspaper so that the public knows about it. And if there are any potential creditors, they can find out about it, and they can file their creditor's claim. And they can come to the next hearing if they want to. And if there's people that want to oppose it, you know, they can also come and oppose it too. Okay? And the publication costs anywhere from $500 to $1,000, depending on which local area the publishing has to take place. I work with a company called Metropolitan News, and Metropolitan News is a legal newspaper, but they have subsidiaries in all the cities in the LA County area, and so they get all the information about the petition, and they publish it, and they'll publish it in the Pasadena Star News, or somewhere in South Central, wherever the area is, they publish it there, and they provide the notice to the court for you, so that they provide a service for you. But that has to be done, though. Otherwise, you can't get the court to approve your administration of the estate. Okay, so just recap quickly here, 'cause I know you might have forgotten. Wills require court filing, publication, hearings, and possible bonds. Living trusts, no court intervention unless there are challenges. Administration of the estate, petition with court, hearings, publication, and bonds. Those are three types of probate matters when you want to pass on the property to your heirs. Okay? Do I have any other question regarding wills, living trusts, or the petition to administer the estate? Yes, Brother Simpson?
I was just wondering.
Oh. Yeah. Okay.
When you say you have to do the publication, is that to let the debtors or people that they owed money know that the person has passed away? Is that the main purpose of that?
Well, it's to let them know that someone has filed a petition to administer their estate. And if you think you have a valid claim, then you have to get that claim in with the court. you have to file a claim notice with the court.
So if they owed, if they owed bills and stuff, they would file a claim in court so that they could get their money.
That's correct, yes.
Okay.
It's called a creditor's claim. Funny thing about debts, when a person dies, the debt usually dies with them. I mean, so if I die, my kids don't have to pay my last Edison bill, okay, automatically. But if there's an estate, though, if I leave an estate, then the estate is responsible to cover any leftover bills that there are. You see, I mean, if you have a credit card with Macy's and you didn't pay it off and you died, your children don't have to pay your Macy's bill. But if there is an estate left over, the estate is responsible to handle, any outstanding bills that person has. Okay, and the publication is one reason why you do that. What you will find out is that once you file the petition, you start getting all kinds of phone calls from realtors, want to represent you, want to sell your house, want to offer their services, because it's a public record, and they find out about it. Okay, all right. So I want to talk about. Yes, Sister Irby?
When there's a credit card outstanding and two people are on this card, one dies, the second person is still responsible. It has to be exclusively for the person who died for the bill to be nullified. Is that true, sir?
Yeah, that's my understanding also.
Can I interject on that? My mother put me on her American Express, right? Yeah. This was years ago. And she died. And American Express came and told me I got a bill to pay. And then they said, no, that was on her. So I had to prove she was dead by her death certificate, submitted it, and they took it away.
Well, what do you mean you were on it?
I was, she put me on years ago to help me build my credit when I was in high school or something.
Yeah, so that allow you to be able to charge things on it?
Yes.
Okay.
But it was under me, the charges that I did under my number on the card that I had. But when I proved that she had died and that wasn't my bill, then I wasn't responsible.
Yeah, I'm not familiar with that, so I won't give any advice on that. But I would say be careful there. Yeah. Yeah. Okay. Thank you. So I want to talk just for a minute about power of attorney. People think that a power of attorney document gives them carte blanche to do all kinds of things on behalf of the person who gave them the authority. And so I want to just dispel that myth. That's not correct. A power of attorney, especially a durable power of attorney, it's a written document, and it directs other people to act on your behalf, but they have to act with your agreement. With your understanding, with your knowledge of it, not on their own, And the person who gives the authority is called the principal. The person who receives it is called the agent or the designee. And so sometimes the agent and designee, sometimes they go beyond what they're authorized to do. A durable power of attorney allows you to take care of a number of transactions or business matters for a person. Banking, you make deposits for them, write checks for them, pay bills for them, take care of contracts for them, sell houses, sell cars. A durable power of attorney covers a lot of different areas, and they usually are checked off or they're typed in on the durable power of attorney form, okay? But it's important, the last bullet point I have there, the agent can only act in accordance with the will or the instructions of the principal, okay? The person with the POA or the power of attorney cannot act on their own. They cannot act in opposition to the principal. So if Betty gives LaBridget a power of attorney, Bridget can't do something that Betty did not authorize. She can't say, I'm doing it anyway. No, you can't. You have to do it in accordance with what she wants. You cannot override the wishes of the person that gave you the authority. Now, sometimes a person becomes ill or incapacitated, and that's where it's good that you gave someone the power of attorney because they need to handle something for you while while you're ill or incapacitated. But that's one of the few times where your knowledge might not necessarily be required. If the illness or the incapacity lasts for a prolonged period of time, then you should probably consider getting a conservatorship over the person, because the power of attorney may not be enough. The power of attorney is not designed to handle everything for years and years. But people do it, though. But that's not why it was designed. And sometimes you need to consider getting a conservatorship, which means going through the court. I put in large letters there at the bottom. This is one of the most common areas of abuse. People trick others into signing a power of attorney, especially older people. And then they go behind their back and they sign papers and do all kinds of unauthorized transactions. So you have to be careful who you give the power of attorney to. And it has to be signed and notarized properly, otherwise it's not even valid at all. Okay? So keep that in mind. There are some other powers of attorney. There's a special power of attorney and there's a limited power of attorney. A special one is given to a person to handle a single transaction for them, like selling a car for them or selling a house for them. A limited power of attorney is for a short period of time, maybe for 6 months. Maybe you'll be out of the country for 6 months and you want your son or daughter to handle things for you while you're away. You give them a limited power of attorney, and it says on it what the duration of the power of attorney will be. Okay, this I think is my last area here, Advanced Healthcare Directive. A power of attorney cannot give instructions on medical care. It's limited. It can do financial matters, but not medical decisions and medical care. For that, in California, you need to have an Advanced Healthcare Directive. Sometimes it's called a California Living Will. Okay, but it's Advanced Healthcare Directive is the proper name of it. It's a document that directs a person to make health decisions or medical choices for someone who is incapacitated or who is unable to make decisions for themselves, medical decisions. And so that has to be, you have to find someone who you trust and talk it over with them before you give them the authority to do that. And it must be filled out on a form or a document. And we're saying decisions like, important tests that need to be run, or procedures that you need to have, or surgeries, or even life-saving measures. If you're incapacitated, you can't answer, you got a tooth on your neck, or you're unconscious, someone has to make that call. And usually it's going to be a relative. If a person is married, it will usually be the spouse. If there's no spouse, it will be the choice like do not resuscitate orders, chest compressions and CPR, emergency transplants, being kept alive by machines, donating organs in case of death. I mean, if you want people to be able to use your liver or your heart after you've died, that has to be listed in the Advanced Healthcare Directive. And even if you want to donate organs for scientific research, it has to be listed in the Advanced Healthcare Directive. And even having an autopsy performed in case there are unusual circumstances. Those things need to be listed in the Advanced Healthcare Directive. In California and other states, they have a thing called the PULSE, which is a physician's order for life-sustaining treatment. It's a form that it's been approved by this agency, the EMSA, but it's a short form that says these are the type of care that the patient wants to have. It should be somewhere posted near the person's bed or near where the person is staying, so that people who come to see them, or even the caregivers, will know how they want to be taken care of. It's a medical order that gives seriously ill patients more control over their own care, and specifies the type of medical treatment the patient wishes to receive, especially at the end of their life. When they get very ill, and they're not going to go on much longer. And this document must be prepared specifically to be legal by a physician, a nurse practitioner, or a physician's assistant who's acting under the supervision of a doctor. And it must be signed by the patient themselves, and the person is in sound mind, and they can make decisions on their own behalf, and they can sign the document at that time, authorizing certain things to be done for them. It should be clearly posted somewhere and maintained near the patient. I even saw one document that said it should be on a brightly colored paper to make sure that no one just makes a mistake there. Yeah. Okay, yes. So I only had I have another area there, conservatorships and guardianships. I'll make that available to you if you want to see my PowerPoint. I had some common questions here that I put here. These are things that people often ask, and I can see you offline. I'll be around all day long if you have these questions. How much does it cost to have a will or living trust drafted? I can answer that question for you. Can wills or living trusts be changed? Answer is yes, but I can answer that. Can I go to the internet and download the forms and file them with the court without an attorney? Yes, but I would not advise you to do that, but it is possible. How do I know which court to file these documents with? It depends on where the property is located. If I don't have a house, do I still need a will or a living trust? That depends. That depends. I would talk to you about that. If I handwrite a will and sign it, will it be valid? Yes, under certain circumstances. And those circumstances are very specific. Okay? Common mistakes. Don't start a will or living trust and not complete it. Don't fail to get the signatures on the documents. Don't lose your important legal documents. Okay? And don't make a verbal agreement over anything with respect to your property or business. Everything must always be in writing. Okay? You may or may not need a lawyer, but it's always good to consult with a lawyer just to find out and to see. Okay? And I have a reference number I can give you there for the San Gabriel Lawyers Referral Service. Or if you want to contact me, I have my contact information there also. And so that being said, I'll turn it back over to the facilitator. Thank you very much.
As you can tell, there's a lot of great information. Again, we just have a little bit of time constraint, but again, in your packages is some of this leave behind material as well. Brother David will be here over lunch. The last part, again, as all of this information integrates together, excuse me, this is for Sister Mary Lou's assistant. I understand Johnny's going to click for you. There you go. This last part is regarding memorial options. Again, Sister Mary Lou's going to come up, and she's going to share her knowledge and information with us at this time. Let's give her a hand, Sister MaryLou Stevenson. You going to come down there?
Good morning, and yes, it is still morning. You ready to click me? Before I get started, I'd like to, there's going to be an introduction of who I am, but I'm going to give you a couple of key words, and they are going to be pre, first word, prior, and planning. Pre means the preparation. It's not on? Oh, okay, can you hear? Okay. Can you hear me better now? This guy wants to really hear from me. If we were home, he would not. Okay, my name is MaryLou Stevenson. I've been a member here since 1975. And in the past 25, 30 years, I've learned this as I've gone. And basically it started as being a new member here and feeling for those who have suffered a loss in the family or church family. And a lot of this started with going out just to make a home visit with Brother Lewis back in the day. And I got into this. I've never taken an official academic course on how to provide a service. I just learned it as I go. So this morning I'd like to share a few tips with you. And the first one will be financial consideration. And once again, let's go back to the key words of planning, pre, or prior. So number one, cash is king. Everybody here know that? Depending on how much you have, cash is still king. When we need to make preparations for a memorial, etc., you have to go through some type of mortuary service. Now, some of you have built-in plans that you've had established for years, and that may or may not change with your situation. There's a credit card that can be used if you have enough on your open balance. There are insurances. You can take out a loan. There are some charitable donations you could try to apply for. A lot of people are doing GoFundMe, but they get a portion of whatever monies you solicit. So having cash, and so when I mention preparation, I'm talking about planning. We plan for most things, whether or not we're going to pay our rent, mortgage, car note, utilities. You need to have a certain amount of money on standby. And, or at time of need, and a lot of us get surprised with a passing of a family member or loved one. It wasn't an illness that went on for a period of time that you could get prepared for. Sometimes it's instantaneous. So you may be able to make arrangements with a mortuary system. Some of the big players are Forest Lawn, Rose Hills, Inglewood, whatever the mortuary service may be, but fees may apply. They may take a policy, they may not. But I'm just going to say that at this stage in our life, and nobody here is 25 years old, we make plans. Please plan for this as best you can. It died? It did. Can you hear me? Better. All right. All right, so one of the things that we run into is the family logistics. David mentioned some of this of who is in charge, basically. Who's going to make these arrangements? A competent adult, a competent child? Prior to the death, if most of you would think about the process of planning a service of any type, hopefully you have made some of your own preparations or arrangements by having a plan in place with a major mortuary system. I'm not here to say go to Joe Blow, or I'm not here to do that. I simply want to say to you, be prepared. And then with some of these things in mind, some of you bought plans years ago, but you could be on a second or third marriage. You're divorced now, etc. You made plans and you bought the whole ball of wax up front, and now you've changed your mind to a basic cremation service. You no longer want that cemetery property that you purchased, so it can be sold. Anything can be done. Back in the day when you went to make a service preparation, you sat down with someone for 2 to 3 hours and looked at your options. Now most major mortuary services are offering plan A, B, and C. No more of the a la carte system of you pay for this, you pay for that. So be careful what you look at, be careful what you've signed up for. If you've done your own planning, preparation, prior to you passing, you can orchestrate your own service. How hard is it for someone that's left standing grieving to come up with your obituary? You can write your own, and I suggest you do that just to make it easy. We're talking about prior planning. Okay. A person with power of attorney can get this started, but a lot of times power of attorney only lasts until you die, okay? Once you're gone, your power of attorney does fall off, correct? So, whatever you'd like to see done at your service or planning for someone else, take their wishes in stride, okay? So, your family situation calls for you to trust your son, daughter, cousin, go with that. Okay. Mortuary services, there's your major players, like I mentioned before. In this area, Forest Lawn, Rose Hills, Oakdale, Los Angeles area, could be Inglewood. But there are a lot of different services that are available. How many of you have made your own plans? Can I see a show of hands of somebody that has already pre-planned what they want? Just know that there could be changes, but if you've already made your plans, great. That's one less thing for your surviving family members. And believe me, it's a hard time. Whether it's been a long anticipated or unanticipated illness, sometimes it's the spur of the moment. an auto accident. You never know how and when we're going to leave. So there's your traditional funeral. It could be at a church or a chapel if you've made the decision to do the one and done stop at these major mortuaries. It could be here at the church building if you're a church member, or you want to use this building for a family member. Having these things taken place ahead of time. Interment is a burial. There could be just a graveside ceremony. There could be a funeral followed by a cremation. So at that time, the major mortuary would prepare the body, loan you a casket for a fee, and after that, the disposition would be a cremation, and what you decide to do with the ashes are up to you. Some people want to keep them at home in a nice little urn. Others hide the urn. Others can bury the urn, place them in a niche. And then this last one is called a whole body donation. That's something very specific. So for those of you who may know or want, it's something that must be pre-planned. You can't just decide at the time of death. This is a freebie. There's no charge to you. So I have information on a card. And I'm sorry, I probably should have made it clear that during the question and answer session after, some of you may not want it publicly announced by raising your hand and asking a question. I will entertain your thoughts if you simply give me your name and number. Some things are just not public. If you want to see me offline, I'd be happy to do that. Okay. When it comes to cemetery purchase, it could be one of the major memorial parks with a traditional burial. An outside purchase is possible, and it could include a vault/liner, because there's a difference. And when you're presented at the mortuary with what's the possibilities are, and you don't know the difference between a vault and a liner. It's simply something to protect the casket from a cave-in. It doesn't have to be a totally enclosed concrete with a top. There's broker assistance. So if you're at a major memorial facility, Forest Lawn, Rose Hills, whoever the big players are, like I said, most of the time now, especially since COVID, they've all come up with the plan A, B, and C. I'm going to say good, better, and best, where they offer some comprehensive packages. A lot of the a la carte services have been withdrawn unless you entertain yourself with learning some of the processes of what they're offering you. Just remember, you're hurting, you're grieving, and you don't want to sit in front of a memorial counselor for 2 to 3 hours to be explained what their process is. You may only want what you had in your mind. We just want to get our family member processed. So just remember, the more you know about the process of going to a mortuary, having to sit down in front of somebody behind the table telling you basically what they offer, not necessarily what you want. There are brokers out there. You may want Joe Blow to do the preparation of the body and provide a memorial/funeral service for you, but there are brokers that can be found, Google, Bing, Yahoo. You are not obligated to buy their property. I'm talking about a burial. I'm talking about a crypt. I'm talking about a niche for those who have cremated remains. You can go offline and buy your own casket. You can buy your own flowers. You can buy everything out there. So just remember, for those of you who have not purchased a comprehensive package, that you can supply some of these things yourself, especially if money's an issue. As well as a lot of people years ago bought their packages, but now they've decided, I want to be cremated. There are brokers out there who will sell you up to half the cost of what the major memorial parks will sell you. So if you have time to research it now, and you know you want to go to be buried in Plan A or Plan B, you can purchase your own cemetery property offline, separate from this. I'm sorry, Michael?
What is a broker?
I'm sorry?
What is a broker?
A broker sells, oh, okay, go ahead. There's agencies out there that will sell cemetery property. There's people out there that will sell you a headstone, a grave marker. It's
Oh.
just that most people are not aware that you don't have to buy it from Plan A, Rose Hills, Plan B, Forest Lawn. A lot of these things can be done a la carte, and it's just a matter of coordinating. But there again, when I talk about preparing or pre-need, basically, to perform your own service if you want it. And wouldn't it be a good thing to do for someone to carry out your wishes and not have to pay $28,000 because that was the plan that was presented to you? We want to be, or some of you may want to be in control of your own memorial planning.
Yeah.
So that's the broker assistance. And then you can make some of these decisions. If you're doing it for a couple, there's some properties out there, especially the older ones, that are dual stacked, 2 caskets, one on top of the other. There's some properties that are side by side. Side by side. Am I still around?
Testing, testing.
Oh, I need a deep voice like Michael, huh? Okay. So,
Question?
yes, go ahead.
Okay, is a broker like an insurance broker or a real estate broker? You can go to that
It's
person and
just
tell.
an outside agent that will sell you what you want. So,
I didn't finish yet.
okay.
But, okay, let's say I contact this broker, and I'm thinking of my father-in-law had a lot of different plots. And I'm wondering if this broker buys plots from people and sell them to other people.
Okay, yes, that's exactly what they do. They offer a service. Some of the brokers will sell you what's available at need. So you haven't done your pre-planning, so they will tell you what's available. You want to be buried at Rose Hills? Other brokers have properties that are exactly ready to be sold off. And you can call and find out what that cost is, whether it's a single, a side-by-side, or an up and down. So there are separate agencies out there that will sell you what you want previous to need. Sometimes you can get it last-minute need, and you know, if you can think about years ago, someone passed away on a Saturday, you could have very well had a service on Friday or the next Saturday. But COVID brought in a whole new logistics as well. There was a slowdown, of extreme increase in cost, as well as time. A lot of these people were working from home, and you could only make a phone conversation 4 days after the fact. You didn't go in necessarily and sit down with them. They kind of told you what may or may not be available. Something, too, that I learned on the way, I did not take a class in this 30 years ago. I kind of learned a lot of this as we went. So, pre-planning is the key. But there are agencies out there that'll sell you anything that you want, even if it's on Facebook Marketplace. There's burial sites available. You don't have to get it. So a lot of times, too, you can use an outside service and bring them here to the church building. And you want to be buried over there in Covina Hills. Well, Covina Hills, if you don't do your funeral service there, they will tell you what day your outside service can bury you. And we've had that happen here. We wanted to make arrangements. If they do everything start to finish, you could probably get it done in about 2 weeks. So anything is possible. You can use an outside memorial service, funeral home, mortuary service, plan it here, and be buried over there. You can get family cars back and forth. Something else we'll come across in a minute is motor escorts, what the law requires now. Before, you may or may not have motorcycle escorts. Now it's just about mandatory. But there's a difference in using the major memorial parks for your need. Okay. Next will be coordination. If you choose to have something here, or you want the church involved in your service, you're going away, you're home going, you need to coordinate it starting with, I'd say, the eldership. They need to be notified of what you think you want and let someone coordinate the minister, the church building, and some of the extras that could be entailed. Video, a pre-reception before the service, a repass after the service. There's a lot of options that could be exercised if we know ahead of time. But there again, let's plan. Let's write our own obituary. Let's buy our own plan now. Let's plan out and let it be known to some of your family members, because we're talking about the adult, competent people that will be servicing you after the fact. Let's choose someone that's worthy. Okay. Worthy. Okay, and then some of the extras are death certificates. I have an official list here of who needs a death certificate. And they're $24 to $25 per certificate, today's pricing. Okay? So the DMV may need one. The court, if you need to go to court after the fact, there's a death certificate necessary. So as you're making your memorial preparations or your funeral preparations, it's easier to plan up front how many you need. And you say, well, give me 2. Well, Social Security may not require you to walk in their office with one, because whoever provides your funeral memorial service, Social Security will be notified by the mortuary. The mortuary must have a date of birth, a name, and a Social Security number. Trust me, before you ever put someone in the ground or cremate them, they have verified who you are. DMV, the insurance companies, and the bank. And before I got, okay, we'll get to that in a second, but credit bureaus. Some people need the official death certificate. And you may get by with 4 or 5, depending on how many financial institutions need an original. But I'll always say it's great to have one extra and some photocopies. Okay. There's extras that are things like flowers, programs to be printed. You can go downtown or use your printing agencies at $8.50 per booklet if you want the fancy pictorial booklet. Okay, programs, you may want some limos or photography or video to video the service, and or if you're doing an official burial or what was the other one? A burial. Some people pay a photographer to come out and video the crowd, actually take photographs. Do you remember that? You don't remember that? Okay. All right. And then, like I said, there are motor escorts that are just about mandatory now. 1 escort per 10 cars. Years ago, it was 1 per 20, and it went to 15. Now it's about 10 cards. Bird release, somebody want the birds flying around as a great send-off. Some have a balloon send-off, but you can't use Mylar. You got to use the regular balloons. And then tying up loose ends. Banking. But once again, before I got started, I mentioned something about pre-planning. Money is king. Cash is king. A lot of people find themselves, "Oh, I wasn't prepared. I went to the mortuary, and they need $10,000 up front." You have a bank account. You have several accounts. You have children. You have left someone in charge of handling your affairs, hopefully, after the fact. I'm going to tell you something that I learned years ago. Your precious bank account should not just have your name on it. If you don't want someone to run into financial difficulty trying to bury you, add a responsible child's name to your bank account. And then they don't have to beg the bank to put a hold on your account to get out $10,000 to bury you. If they're a signer on your account, we don't run into these issues. I don't want to go too far into that because I don't know how many of you have responsible children that can take care of business for you. But it's important that if they're listed as a beneficiary on your bank account, don't you know it takes about 3 weeks to get your official death certificate to where now you can go to the bank and hold your head up high and say, "I have the death certificate." That's 3 weeks later. You needed to take care of business 3 weeks ago. So for those of you who would think about that, adding your children or your responsible child or whoever your designee is going to be to your bank account. And they don't have to go begging to let me get some of mom and dad's funds. Insurance processing, there again, it takes some of the official death certificate to apply or get the process started. The DMV may or may not want it to get their little blue tag back or kill that number on your handicap placard. They want to be notified. Social Security will be notified by the processing mortuary, but just in case, you have an extra original that you've ordered that you can carry around. Retirement benefits, and then there's the disposition of your personal property. Some people mention keeping the house, some people mention this, that, or the other, but there's a process that you need to go through. Even if you keep the house, you don't want all the clothing and the furniture, and then if you're like my two, they may not want my china that's hidden somewhere. You know, so some things just need to be gotten rid of. Clothing, things that meant something to them but not to you. So. Okay, I know that was a quickie. There again, like I said, here's an option. Sometimes you have a very ill family member who was not necessarily a church member or a church goer. They know that they're going out and they don't want any of the frou-frou that we go through with your traditional funerals, cremations, etc. There's a way to process their body for free, but you need to be pre-registered. I've done this twice for a family member and a church member here in the past. It's totally free, but you must be pre-registered in the system. Question, David?
Yeah, MaryLou, what's your take on the insurance costs, like colonial pin and those type of burial insurance policies?
Let's get you online.
I thought it was loud enough.
No, online.
Yes, MaryLou, what's your take on colonial pin and other burial insurance policies?
Okay, a lot of times, especially depending on what channel you watch as to how often you see those advertisements, you could get for $7 a month, it should say $7 every other day, to get you $10,000 worth of insurance. Do your due diligence for the research. $10,000 is not necessarily going to take care of it. Depends on how old you are. They say no medical is required, but it doesn't pay very well. And you need to start that before you're 80 because that's the cutoff. If you're 80 years old, they're not going to take you on.
MaryLou, I don't think that Colonial Penn is licensed to write those policies in California. Would you double check me on that?
I don't know specifically. I just know from reading the fine print on some of these entities that they don't pay very well. And if you think you're ill and you're going to purchase a policy and it's not in effect for at least 2 years, it's not going to pay off as well.
It is effective, but it is 2 years in order to kick in, and I'm like, man, we'd be dead, buddy.
Right. Because a lot of people wait too late. There again, it's talk about preparation, pre-planning. Okay?
Yeah, that kind of answers some of my question because the 2-year period before you actually get before you actually can utilize that insurance is I kind of went through that myself with one of my family members this time. But I was wondering, are those burial plans that the mortuaries sell, are they pretty good? I mean, it's
I don't know a lot about them other than read the fine print. Make a call yourself and see what the representative on the other end tries to fast talk you into signing up today. And like I said, it depends on age, but they don't put that age in large print on the TV ad. Anybody over 80, they're not going to take you on. And it has to be in effect for at least 2 years. So you could start a plan now for somebody. And when I talk about pre-need, I'm trying to get you to get ready for the process of taking care of yourself, and then you can help take care of others. A lot of the major parks will sell you a pre-need policy, but the bank will also, with better interest rates, you set some money aside just for things like this. You have a vacation account, a housing account, let's think about our exit account so that you don't become a burden to others. I don't need a car wash on Saturday. I don't need a GoFundMe page. Let's prepare, and like I said, a lot of you have plans already in place. Review that plan and that's how the brokers become involved in a lot, where people have bought the complete package years ago, and now Joe Blow has decided, I don't want any of that. I'm going to be cremated and have a little service maybe. So I am now selling my property, cemetery property. That's how you can get a better rate if you pre-plan. If you wait till the person has passed, then you're calling 2 or 3 brokers to see what property's available where. And yes, it still costs more, but I bought mine back in 1976, 77. So yeah, it has escalated, but I'm holding on to it. Yes.
No, I was just going to say, if it's someone older than 80, they really make it difficult for you when you start buying these plans. It's super expensive for one thing. It doesn't kick in until after 2 years, but then the whole process is just, I mean, you know, because your back is kind of against the wall in trying to do so. I had this conversation with you before.
Yeah. I think we need to think about, Michael kind of mentioned something earlier about trying to save up this over here so that we can have something over there to leave. I said take care of your need now. It's about you, and then the children or grandchildren can take care of their needs as well. But right now, I want to go out of here peacefully without a lot of debt. Cecil?
I want to share some information. In regards to banking, I went through this with my father-in-law. He had me as the POA upon his death.
Right.
And he didn't trust banks. When I went to his bank upon his passing, they made me wait 45 days.
Right.
But however, the fact that he didn't trust banks, he had money in mattress, so to speak.
Cash is king.
Yes. I was able to do transactions with the mortuary because he had pre-planned.
Right.
He had pre-planned.
Prior.
Prior.
Preparation.
Yes. And so And the other thing, too, when I went through this, when Roxanne passed, she had a policy, and we had arrangements with Forest Lawn, and I just signed over the insurance deal to them, and they did everything.
At
And
no
they-
cost?
Yeah, yes. And of course, they gave me what, it took what
They needed. and
they needed
the
and
rest
gave me
was
the
yours.
rest,
Right.
which was great.
But that was pre-planned.
That was pre-planned.
Pre-planned. Key. Cash up front, pre-planned. Okay, is that it? We ran over because of Marcia and David, so.
One other thing is just what I found on the fact of using Costco.
Everybody has there's outside entities out there, and then they had to stop that extra charge, but anybody can sell you a casket. But a lot of the mortuaries found there's a receiving fee. Costco will sell you a casket and charge you $89 to get it there, and then the mortuary charged you $189 to receive it. So sometimes you may want to go with this. Sometimes you may not need a casket. I don't know. Everybody doesn't need a casket. But if you want to have a funeral, rent the casket and we're done. It's up to you. The choice of how you go out of here, you all got to die to just get somewhere else. Okay. All right. Thank you.
Outstanding. Okay, she's got the freebie cards there. Again, just want to thank all three of our presenters. Can we give them all a hand, please? Did a great job, really, really great job. Thank you all for the engagement and for the questions. Like I said, they'll be here. I already talked to Brother Jose. Lunch is already being prepared for us. We're going to dismiss, going to ask Brother Mike to dismiss us and also to bless the food. And I'm going to ask the presenters, MaryLou, David, and Marcia, to come up front so I can take some pictures for our records. Again, thank you, everyone. Greatly appreciate it. Let us stand, and then Brother Mike, if you'll dismiss us, please. Oh, and lunch is in the same place, breakfast in the fellowship hall, right in the back.
Let us pray. Dear Heavenly Father, we come just humbled, Father, for all your many blessings that you give us, Father, including today, Father. Thank you for allowing these three individuals to come and impart upon us things that we know we're all going to have to deal with at one time, Father. Father, we just ask that everything that we do this day was done decent and in order. And we ask, Father, that you continue to give us all the open understanding that we all must go that way, and we all prepare, as the sister said, Father. We continue to thank you for the food that was prepared, Father, and may it nourish our bodies and give us the strength to go out and spread your word, Father, upon those that don't know you. We seek you this day, Father, to continue to lead us, Father, in the ways that we know are right. We ask these prayers in your Son, Jesus' name. Amen.